I received urgent communication this morning at 6:47 a.m. from Federal Court Monitoring Systems. What I'm about to share contradicts 3 years of official denials. I've built cases for 30 years as a federal prosecutor. This isn't speculation. This is documentary evidence. The filing landed in the Southern District of New York Electronic Docket System at 6:32 a.m. Eastern Standard Time. Exhibit 47C, 17 pages, Melania Trump's sworn deposition testimony. Page 9 contains language that changes everything we thought we knew about the classified documents investigation. Let me read you the exact words from the court transcript. Question from Special Counsel Jack Smith's team. Mrs. Trump, did your husband ever instruct you regarding testimony you might provide to federal investigators? Answer: yes. Follow-up question: can you describe that instruction? Her response spans 43 words. I'm going to read it slowly. He told me specifically that if asked about documents in his bedroom and bathroom, I should say I never saw anything. He said this directly to me on 3 separate occasions between June and August 2022. That's under oath, under penalty of perjury, with federal marshals present in the deposition room. Now, here's what makes this devastating. We have contemporaneous evidence, text messages, Signal app communications, voice recordings that Melania's personal attorney preserved as protective documentation. The special counsel's office obtained these through a separate subpoena to her legal team. They're cited as Exhibits 48A through 48M. Exhibit 48D is a text message dated June 18, 2022, 10 days after FBI agents first visited Mar-a-Lago requesting return of classified materials. The message reads verbatim: remember what we discussed. You saw nothing in my private spaces, nothing in the bedroom, nothing in the bathroom. This is important. The metadata confirms it was sent from Donald Trump's phone to Melania's phone at 11:34 p.m. The digital forensics are irrefutable. Exhibit 48G is even more specific. July 22nd, 2022, another text message. Jay talked to me about your potential interview with FBI. Keep answers simple. You never entered my bedroom when documents were present. You never saw classified markings. You were focused on Barron and design projects. Jay is Jay Sekulow, Trump's attorney at that time. This message directly connects legal strategy to witness instruction. That's suborning perjury. That's obstruction of justice. Federal Statute 18 U.S.C. Section 1512. Let me translate what this means in plain language. When someone tells a witness what to say to federal investigators, that's a felony. When that instruction is specifically designed to hide criminal activity, that's conspiracy to obstruct justice. When it happens multiple times with documented communications, that establishes pattern and intent. I prosecuted a construction company executive in 2007 who did exactly this. He told his project manager to lie to OSHA investigators about safety violations. He got 14 months in federal prison. The project manager who followed those instructions got immunity for truthful testimony. The legal principle is identical here. The special counsel's filing includes legal analysis starting on page 11. It cites United States versus Poindexter, a 1990 case involving the Iran-Contra scandal. The court held that instructing a witness to provide false testimony, even if that testimony is never actually given, constitutes complete obstruction. The crime is the instruction itself. Here's what the timeline reveals. May 11, 2022. National Archives refers the case to Department of Justice. May 23, 2022. FBI opens criminal investigation. June 3, 2022. DOJ attorney and FBI agents visit Mar-a-Lago. June 8, 2022. Trump's attorney signs certification that all classified documents have been returned. Then, June 18, 2022. First documented text message to Melania instructing her on what to tell investigators. This is 10 days after his lawyer certified full compliance. He already knew that certification was false. We know this because the August 8, 2022 FBI search recovered 103 additional classified documents. July 22, 2022. Second documented instruction to Melania. This is 6 weeks before the search warrant execution. Federal investigators are actively seeking interviews with household members. Trump is coaching his wife on false testimony during an active federal investigation. August 8th, 2022. FBI executes search warrant. Agents recover those 103 classified documents from his bedroom, bathroom, and storage areas. The exact locations Melania was instructed to deny seeing documents. August 17th, 2022. Third documented instruction, Exhibit 48K. A voice memo Melania recorded on her phone. She's speaking to her attorney. She says, "He told me again today that I need to be consistent, that I never saw anything. He's very concerned about what I might say if they interview me." She recorded that conversation with her own lawyer. That tells you she understood something wrong was happening. That's why her attorney preserved these communications. That's protective documentation when you realize you're being drawn into potential criminal activity. The emotional weight of this cannot be overstated. Melania Trump stood beside this man through 2 impeachments. She defended him through multiple investigations. She maintained public silence while media scrutiny intensified on their family, and his response was to use her as a potential false witness, to instruct her to commit perjury to federal investigators, to prioritize his legal exposure over her legal jeopardy. Because make no mistake, if Melania had followed those instructions and lied to FBI agents, she would have committed a federal felony. She would have faced prosecution herself. Her son would have potentially lost his mother to federal prison. Trump was willing to let that happen to protect himself. The filing includes a statement from Melania's attorney, dated December 3rd, 2024. It reads, "Mrs. Trump has cooperated fully with the special counsel's investigation. She has provided truthful testimony. She has produced all requested communications. She deeply regrets being placed in this position." That's legal language for, "My client is telling you everything because she's not going to prison for him." Let me know in the comments whether you think this is the most significant development in the classified documents case, because from a prosecutorial standpoint, it transforms everything. Previously, the strongest evidence was security footage showing Walt Nauta moving boxes at Trump's direction. Strong evidence of obstruction, but that requires proving Trump knew what was in those boxes and intended to conceal them from federal investigators. This evidence eliminates all ambiguity. Trump explicitly instructed a witness to provide false information about document locations. He did it multiple times. He did it through documented communications. He did it during an active federal investigation. That's textbook obstruction. Pattern recognition is how federal prosecutors build conspiracy cases. You look for repeated behavior that shows consciousness of guilt. Once is accident, twice is coincidence, 3 times is pattern. First instruction, June 18th. Accident. Maybe he was confused about what investigators wanted to know. Second instruction, July 22nd. Coincidence. Maybe he was just anxious about the investigation. Third instruction, August 17. That's pattern. That's someone who knows they're hiding evidence and is systematically preparing witnesses to conceal that evidence. The pattern extends further. We know Trump instructed his attorney Evan Corcoran to certify all documents were returned when Trump knew that was false. We know he instructed Walt Nauta to move boxes before attorneys could review them. We know he instructed maintenance worker Carlos de Oliveira to delete security footage. Now we know he instructed his wife to deny seeing documents in locations where 103 classified documents were ultimately recovered. That's not panic. That's not confusion. That's systematic obstruction involving multiple witnesses across multiple months with consistent objective. Hide the documents, prevent their return, deceive federal investigators about their location and quantity. I prosecuted a pharmaceutical executive in 2011 who destroyed clinical trial data and instructed 3 employees to deny knowledge of safety problems. Similar pattern of multiple witnesses receiving similar instructions. He got 42 months. His company paid $180 million in penalties. The legal jeopardy here is exponentially greater because we're talking about national defense information. Documents marked top secret SCI, documents containing human intelligence sources, documents revealing military capabilities. The Espionage Act violations carry potential 20-year sentences per count. Add obstruction of justice. Add conspiracy to obstruct. Add suborning perjury. You're looking at hundreds of years of potential exposure across multiple counts. But here's what really matters for national security. Why did Trump fight so hard to keep these documents? Why risk his wife's freedom? Why instruct multiple people to hide evidence and lie to investigators? What was in those 103 classified documents that justified this level of obstruction? We don't have complete answers yet. The special counsel's filing remains partially redacted to protect ongoing intelligence assessments, but the behavior tells you everything. Innocent people don't create elaborate cover up schemes involving their spouse, lawyers, and household staff. Innocent people don't send midnight text messages coaching witnesses on false testimony. Innocent people don't have their wife record conversations with lawyers because she's afraid of legal jeopardy. The Melania testimony also creates impossible strategic problems for Trump's legal team. They've spent 2 years arguing this was simple negligence, just sloppy record keeping, presidential materials mixed with personal items, no criminal intent. That defense disintegrates when you have documented instructions to hide evidence and prepare false testimony. You can't simultaneously claim innocent mistake and systematic witness preparation. Those positions are legally incompatible. Trump's attorneys will argue Melania is cooperating to protect herself, that she's exaggerating his instructions to minimize her own exposure. That argument requires calling her a liar under oath. That requires attacking the credibility of his own wife in federal court. That creates catastrophic political and legal optics. Alternatively, they argue the instructions were innocent, just reminding her she didn't see anything because she actually didn't see anything. But the August 8th search undermines that defense. Documents were exactly where she was told to deny seeing them. If she genuinely saw nothing, why the repeated coaching? Let me know in the comments whether you think Republican leadership will finally acknowledge this evidence, because we're past the point of political spin. This is sworn testimony from his wife, saying he ordered her to lie to federal investigators, backed by text messages, voice recordings, and 103 classified documents found exactly where she was told to deny their presence. The call to vigilance is this: we're watching whether our justice system applies equally to the most powerful among us. We're watching whether documentary evidence and sworn testimony matter more than political calculation. We're watching whether obstruction of justice and suborning perjury carry consequences regardless of the defendant's name. Every American should care about this case, not because of political affiliation, because these documents contained intelligence sources. They revealed military capabilities. They exposed our nation's most sensitive secrets, and someone fought desperately to keep them, used his wife as a potential false witness, risked her freedom to hide evidence. That demands answers. That demands accountability. That demands prosecution if the evidence supports it, and the evidence does support it. 1,800 pages submitted to Judge Aileen Cannon. Exhibits including text messages, voice recordings, security footage, witness testimony, and now Melania's sworn deposition describing direct instructions to provide false information. No one is above the law, not presidents, not former presidents, not their families when they become witnesses to potential crimes. If you found this analysis valuable, subscribe to this channel. Share this video with people who need to understand what's actually in these court filings. And stay vigilant, because this case will define whether our justice system functions for everyone or protects the powerful. Truth matters, evidence matters, and today we got both.